Hi, everybody. This is attorney Andy Marcantel and attorney Mark Victor. We are the partners and criminal defense attorneys at the Attorneys for Freedom law firm. We do self-defense cases all of the time, and we get lots of questions about the different products that different insurance companies and self-defense groups are offering, and we're often asked to analyze those. We want to do a little bit deeper of a dive today, Mark, into what I thought was a pretty shocking example of some of the problems surrounding these insurance companies.
Yeah, I think that people sign up, I think with in good faith, right? They sign up in these programs because they've heard all kinds of horror stories about people, really good people, right? People who are doing their best to try to follow the law, and they find themselves in a situation, they got a second or two to think about it. They maybe pulled out their firearm, just brandished it. Maybe they discharged around. Maybe they just pointed it at somebody. All kinds of different scenarios.
I think that's a good segue to get us to the Kayla Giles case. You want to talk about this case,
Why
Mark?
don't you give us a quick overview and I'll jump in.
So Kayla Giles was insured by the USCCA. And she
was a platinum member, as a matter of fact.
I don't know the difference between their different policies, but
she purchased a high-level package.
It sounds very fancy.
It's very fancy.
You would assume as a platinum member you would have your criminal defense paid for, especially if you had a good lawyer who was picked out by USCCA saying this is a great defense case. And in fact, that's exactly what Mrs. Giles had.
Yeah, so she signed up. She's a platinum member, so she's got the higher level of coverage, $150,000 set aside, ready to go for your criminal defense lawyer in the event you are charged with a crime and you acted in self-defense. So, yeah, that's exactly what happens with Kayla Giles. And if you want to give the little summary of the story.
Yeah, she got a criminal defense attorney. The case took place in Louisiana. And I think the facts were roughly that she had an angry ex, maybe husband or boyfriend or something.
They were swapping the kids or something.
Banging on the door, threatening her through the door, trying to burst in. And
she was in fear for her life.
Claimed to be in fear for her life, and she fired a firearm and ended up killing him. And she was a USCCA member. She called the company USCCA. Actually, I think I had done a little research that she was attacked in the media for immediately calling USCCA.
Yep. But that's what they tell her to do.
Because that's what she was instructed to do by
Call
USCCA.
the USCCA, say you've been involved in an incident, we'll get you a lawyer, we'll cover you, no problem, you got $150,000 worth of coverage. So they get her a lawyer, nice guy. You and I spoke with this lawyer. This is not secondhand information. We had a very nice conversation with this lawyer whose name I think we should probably keep out of it. But he was very open and very frank with us. And the important thing people need to understand is what he said was, Kayla, in my judgment, this is a guy been practicing a long time.
And has done a lot of self-defense cases.
Just same type of lawyers as we are. Real lawyers do real cases, go to trial in the trenches like we are. He says, this is one of the best self-defense cases I've ever seen. I was very excited about defending. You know how excited we get when we get a good, arguable self-defense claim. We're excited about going to trial and bringing that. That's how this guy was. And USCCA, right out of the box, was off to a good start. Here's $50,000. Get started defending our insured. And in fact, again, to be fair, it really wasn't USCCA. It was the insurance company. And I think there was another insurance company. USCCA is not really involved in this part of it, right? It's an insurance company. And as I like to say, it's the bean counters over at the insurance company who are making the decisions over what's going to be covered here and what's not.
Right. So what ultimately happens is he gets the discovery in the case, he gets the police report, he gets some of the initial disclosure, and as part of his agreement with USCCA as the representing lawyer, really with the insurance company as the lawyer who is representing Mrs. Giles and getting paid by them, he has to send them the discovery. And this is part of the cooperation clause that we've discussed in some of our previous videos. So as part of that cooperation, he sends the discovery over to the insurance company. Well, what happens? The insurance company gets back to him and says, we've determined this is not a self-defense case. She acted criminally. She committed a crime here. Therefore, no more coverage. You're on your own.
Which is really a very important point here because, it's possible that you don't get to argue self-defense in court, right? I mean, somebody breaks into your house, shoots another person, or shoots somebody while they're sleeping. There's not a good argument they shot the person while acting in self-defense. There's not any argument here. A judge isn't going to let that go to a jury with self-defense instructions. But in this case, the judge indeed did allow the jury to be instructed on self-defense. So she met her, what we like to say, burden of production, right? She got involved and said, hey, at least the lawyer may have made an offer of proof to say, hey, judge, my client is going to testify that she was in imminent fear of death or serious bodily injury from this person banging on the door, and that's the reason she pulled out her firearm and fired it through the door.
Let's say a word real quick about the burden of production. It's really important, and a lot of people who don't understand how the court system works, how the criminal justice system works, this might be a foreign concept. As lawyers, as criminal defense lawyers, we can't just go into court and order anything without any evidence whatsoever. We have to make what's called a preliminary showing,
Prima facie case.
We got to meet our burden that there's at least some evidence here in order to argue that. So in this case, he went in and without determining whether or not, obviously, this was a valid self-defense case, because that's the role of a jury, the judge said, in my view of what you've shown me, Mr. Lawyer, there's at least enough good evidence here that you can argue it to the jury, and the jury can find it. I'm going to allow the jury to find that this could have been self-defense. So he met that in this case.
And oftentimes the judge is going to say, look, you got to present something at the trial, but if somebody gets on the stand and says what you're saying they're going to say, then I'm going to allow this to go to the jury. So that's exactly what happened here, and that shouldn't be a surprise to anybody. I mean, this lawyer told us he thought it was a solid self-defense case, or at least an arguable self-defense case. And there's never a time when you say, I have a winning self-defense case, right? You just never know what a jury is going to do. So there's never an occasion where you say, this is guaranteed to be a self-defense case. What you have is probable cause has been determined either by a judge at a preliminary hearing or a grand jury that a crime was committed, right? There was a death that was committed, a murder was committed, an assault, an aggravated assault, an attempt crime, something like that occurred. There's probable cause to believe a crime was committed. That's what the charge is. So really, right at that point, the insurance company could say, if they wanted to, we agree with the grand jury. We agree with the judge. There is good reason to find a criminal act has been committed. No coverage. They could do that in 100% of these cases. And in essence, that's what happened here.
Yeah, so just to be clear, if this doesn't make you lose faith in the security that these types of programs give you, we now have two licensed members of the bar, at least. The lawyer, the defense attorney, who's a seasoned criminal defense attorney who does lots and lots of self-defense cases, and the judge, who's the neutral arbiter, and both of them are saying, in our opinion, there's at least enough evidence here to make a case for self-defense to a jury. And over both of their opinion, this non-lawyer insurance company, with presumably no legal training whatsoever, because he told us he wasn't working with lawyers and hired by the insurance company, it was just the insurance company directly, they unilaterally just decided, in our opinion, it's not self-defense.
Yeah, we're not sending any more money. She loses her lawyer. He gets off the case. I don't know if she had to get a public defender, but she sues USCCA and Delta Defense to say, look, I'm a member of, I signed up for exactly this. You're not paying me my benefits. And as often is the case, when there's a civil case pending and a criminal case pending, they stay the civil case. That's what happened here. The criminal case proceeded. I don't know who her lawyer was. She went to trial, and like many cases where people think they have self-defense, she was convicted. And so when the civil case proceeded forward, this was an easy one for it to be resolved, because this is a criminal act. She was convicted of a crime. Easy. She loses the civil case. So in my mind, it raises the question, if I'm an insurance company backing any of these programs, why don't I always take the position?
Yeah. That's a very good point. Like, let's walk each of their options out to its logical conclusion, right? So a purported self-defense of one of their insured incident occurs, and they now make the claim for the lawyer. So walk through each of those to their logical conclusion. Okay, so first they could just deny the
Well, the first
claim.
Stop is one of our insureds has said they've engaged in an act of self-defense, and now they want to be covered. Well, let's look. Did they get charged with a crime? Oh, you're charged with a crime. Well, that means that there's probable cause found by either a judge who's reviewed all of the evidence at the preliminary hearing, or usually 12 or maybe 9 members of a grand jury, or maybe 16, depending on the jurisdiction, have found that there is probable cause that a criminal act was committed.
That's much lower than beyond a reasonable doubt standard needed to convict.
Let's look at our contract. Oh, I see criminal acts are specifically excluded. We deny coverage.
Right.
And that could be the end right there. That's it.
Just if you're charged with a crime.
You're charged with a crime. It's a criminal act. We don't cover criminal acts. That's the end of that.
Yeah.
Boom.
Now, say they accept coverage, right? Even if you walk both of these to their logical conclusion, they're going to be incentivized to deny the claim, right?
Yes, I mean, they could do what they did in the Kayla Giles case, say, well, we've changed our mind, we're not sending any further money. They could say, oh, you took a plea? Not only are we not giving you any further lawyer services, we want the money we've expended back because you like the roughly 95% of people in the criminal justice system took a plea. Imagine it's actually a good self-defense claim. The person's charged with first-degree murder, and the prosecutor feels like, yeah, this is really a tough one, and they negotiate something, maybe down to like an involuntary manslaughter type of a thing, or maybe something even maybe lower than that. Let's give them something else. And or you can imagine a situation where it was even an endangerment because there was another person standing around. They struck some kind of a creative deal. You think it's a big victory. You got probation. I got a low-level felony. I beat a first-degree murder rap. The insurance company can say, sorry, this is a criminal act. Not only are we not covering anything, we want back the money that we expended. So it's going to be very difficult. I mean, for you to have a really clean claim here against the insurance company, you have to go to trial. You have to win at trial.
Right.
Yeah. And now imagine that. Imagine they have denied coverage and you went to trial.
And won.
And you won at trial and now you sue them. You're going to win, but are they in any worse position? They're going to have to pay exactly the same amount of money. The $100 in the case of Kayla Giles.
She would have gotten $100,000 more. She would have gotten what she was promised for her platinum membership.
They're not really out anything. They have
I would
to pay
hate to see
claim.
the bronze membership if that's the platinum membership.
Yeah, and if you think you're going to make the argument that, well, I went to trial with a public defender because they didn't cover me and I got convicted and I would have been acquitted had they paid the claim and I could hire a private lawyer, you're going to have a very hard time with that, right? Because the public defender's job, if you get convicted on that case, the question is going to be on appeal, did they act in a way that amounts to ineffective assistance of counsel? If they didn't provide ineffective assistance of counsel, you're going to have a very hard time showing that this now effective attorney who you still got convicted with, another effective attorney, you got the burden of proof to show you would have been acquitted if you want to beat that civil claim and force them to pay the freight on that case. I think that's a very hard argument. In fact, I don't see it ever winning.
Yeah. And Mark, the more you and I have talked about this, about where the incentives are in terms of where is everybody's incentives when you're analyzing these deals.
Follow the money, right?
And follow the money. And your point was that it seems that the insurance companies are just incentivized to try to deny as many claims as possible, which makes sense. It's how insurance companies remain profitable, right? But there's one more incentive to be fair here, which is that they can't deny every single one of these. They need to accept just enough of them so that enough of these similar stories don't get out, or otherwise people wouldn't patronize them.
Yeah, let's go through those slowly. First off, let's just take the roughly 95% of cases that plead. 95% chance that the insurance company that denies the claim, without even looking at another thing, 95% chance they're going to be able to say, hey, it was a criminal act.
Right.
We don't have to pay anything. So, I mean, if you just said to the insurance company, deny the claim, there's a 95% chance that you're going to be justified. There'll be a criminal act here, and you do not have to cover it contractually speaking. That kind of ends it right there, right? But as you point out, if they did that in 100% of the cases, then eventually the word's going to get out, hey, these guys never cover anything in the criminal realm. So they're probably going to have to cover something somewhere. I don't know, maybe they decide they don't want the big murder cases like the Kayla Giles, but the small brandishing.
See, those are the cases as real criminal defense attorneys we get excited about.
Yeah. Maybe they say, okay, here's a case where somebody brandished something. It was sort of a low level, maybe a disorderly conduct. The person said, I acted in self-defense. Not going to be that expensive of a claim for them to pay. Maybe they pay it so they can put it on their website and say, hey, look, we actually defended somebody here.
But given that now that we know that the insurance company can just unilaterally decide that they like this case or they don't like this case, what does that say for the peace of mind that somebody would get from patronizing one of these companies, right? I mean, it doesn't seem like it exists.
Yeah, don't take our word for it, right? Take a look, go to Google, put in Kayla Giles, Giles, and do your own research here. In fact, there's another attorney, Andrew Branca, I think he's at lawofselfdefense.com. He went through the whole case. Interestingly enough, he's pitching CCW Safe, which I also did a video on.
I noticed that, yeah, while he was kind of dogging on USCCA insurance providers coverage here, he then goes on to endorse a company that has exactly the same problems in their contract.
Criminal acts totally excluded.
And he's like, this is the one I've decided, without even addressing how everything that he just critiqued USCCA for is pretty much applicable to the same product.
Yeah, so anyways, research this case yourself and then ask yourself, do I really feel comfortable that if I get charged with a serious felony offense and I've got a claim for self-defense, one I could bring to the jury, that the insurance company isn't going to just pull the rug out from under me, knowing full well there's a high probability that there's going to be some criminal act in there somewhere. I mean, you can avoid all of this by, instead of dealing with the insurance company indirectly through USCCA or one of these other companies, you deal directly with the law firm.
One more point that I just feel the need to make. I'm compelled to make this point because
Make your point, man.
Because I like practicing with integrity, and I think practicing the law ethically is really, really important. Mm-hmm. And as our ethics counsel at this law firm says, we are the most ethical law firm that she has ever worked with. She's got nothing but good things to say about every single thing that we do at this firm. We want to make sure is done ethically.
Yep.
This, as it's called, tripartite relationship that exists in these programs between the attorney and the client, that's the normal attorney,
and the insurance company, yeah.
And then the insurance company being tacked on. The insurance company who has unilateral power to revoke the representation at any time, basically, gives me a lot of ethical problems.
And
gives me a lot of ethical qualms with this.
Think about the lawyer who's getting paid the fee by the insurance company, right? They don't want to annoy that insurance company because they might want to get future fees, right? So, look, they have an ethics responsibility to represent the client, but you can't totally ignore the financial, where the money's coming from. And so, each of these companies is different. They got different rules, and some of them you can pick an attorney, and some of them they pick the attorney for you. So I think this is more applicable to when they pick the attorney for you, because that attorney probably is looking for future business. So it'd be very hard for that lawyer.
Maybe not. Even if the client picked their own attorney. Look, the bottom line is this, is that whenever we're analyzing a case and we're getting that discovery, we're going through the same process that Mrs. Giles' lawyer went through, where he's receiving all that discovery. There's no such thing as a perfect case. You're going to see good facts and you're going to see bad facts.
Right.
A lot of time the good outweighs the bad and vice versa, but it doesn't change your obligation to the client as their lawyer. It shouldn't change your obligation.
It should, but you may.
And so now, if you're holding on to bad facts that you discovered and you have a contractual duty to cooperate and send all of that stuff over to the company that you know that if they see enough in their opinion, in their non-lawyer, unqualified opinion, they have determined constitutes a criminal. Too many bad things here. Can you be ethically required to cooperate with that part of the contract?
It's a hard position to put a lawyer in.
I would, if I was sitting there, I don't want to send this to the insurance company.
Right.
I don't want to send this to them at all. I mean, I can't. My duty number one is to my client. I got to make sure my client makes it to the finish line and gets the best result possible. If I send this over to them as contractually required and they yank the rug out from under them, that's gonna make me feel horrible for them.
And what happens if you don't cooperate? That's probably a reason by itself. The lawyer's not cooperating with us. We can't make judgments about the case. It's in breach of contract.
Yeah, I would rather violate the contract than knowingly jeopardize my client's position.
There's a way to avoid all this.
Don't screw around with insurance companies.
Deal directly with the law firm. If your concern is, I want to make sure that I got experienced, aggressive, professional criminal defense lawyers on my side. If I get charged with a felony offense and I can allege self-defense, we can get that self-defense case to the jury, which means the judge is going to allow a self-defense argument. That's it with us. As long as the thing arose after you signed up and it's a felony and we can bring a self-defense claim to that jury, we're in.
Right.
It doesn't matter that the firearm was illegal, that it was an act of domestic violence, that it's a criminal act, that the gun was illegal, or any of these other countless exceptions and exclusions. Read your contract if you're with one of these other companies. Now, look, if you want the bells and whistles, you want the scene cleanup and the bail and this and that, fine.
I'm not cleaning your house.
No, we are not going to clean your house. But we will defend you in a criminal case.
We'll make sure you can go back to your house after you use your firearm to defend yourself and your family rather than going and living in a cage for any amount of time.
I tell people, if there's a way to beat the case, we'll find it. And if we can't beat it, it can't be done. That's what not every case, some cases need to plead, right? It depends on the facts. We can only play the cards that we're dealt, but we will play them. Nobody plays them better than we play them. And we've had many, many successes at our law firm. I hope people will also do some research on the Attorneys for Freedom law firm. Check us out. We're ethically restricted from talking about almost all of the cases that we've but there are some online.
Most people who come in have done their research. Most people who sit down with you and I have researched. They're here because they've researched our law firm and the things that they've seen, our high-profile cases, everything like that. But every now and then I get one in my office who said, I Googled you guys and look, you had a nice website and everything. I'm not too familiar with your work. I always tell them, when they're sitting in my office trying to hire me, I tell them, never hire an attorney unless you have thoroughly researched that law firm.
I say the same thing.
Absolutely vet any attorney before giving them a dime of your hard-earned
money. The more information you get, the better. So if you like the sound of that, right, if you're comfortable with the fee and you knowing you're not going to get the bells and whistles and you check out our law firm and you come to the conclusion so many other clients have over the past 30 years that, nobody brings it more aggressive, nobody thinks more creatively outside the box, nobody is more committed to self-defense arguments and defending people. We love these kinds of cases, and we do them aggressively. We have excellent reputation in the community. I think I can say very comfortably that no law firm is more well-respected, at least in our community, than we are. And so if you're comfortable with all that, check out the Attorneys on Retainer program. It's pretty easy to find out information about it. Go to our website, attorneysforfreedom.com. Check out Attorneys on Retainer. It's pretty simple. If you want lawyers making decisions about your case, not insurance companies, then this is probably the program for you.
Awesome. Attorneysforfreedom.com. Click on the big old red Attorneys on Retainer button at the top. Marc, great talking to you today, man.
Same here, man. It's always a good time talking about this.
We're just asked so many questions about these types of programs and what Attorneys on Retainer, how it's different. And so, it's just important to talk about this stuff.
Hopefully this addresses questions. If not, give us a shout.
Yeah, absolutely.
Email us, call us at the firm. Happy to answer your questions.
Also, make sure to like and subscribe to our YouTube channel. We've got all kinds of social media all over the place, links in the description. If you have questions that we didn't answer today, make sure to throw them down in the comments. We answer all of our comments, and we can't wait to talk to you. Thanks a lot, guys. Attorney Andy Marcantel and Attorney Marc Victor. Take care.
Peace.